judicial branch of the Philippine government, judiciary.
Essential features of the judicial branch of Philippine government. As indicated in Article 8 of the 1987 Philippine Constitution as of July 15, 2020 at the webpage of the official gazette of the Philippine government. The judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. As defined in the same article, judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch or instrumentality of the government. The role of judiciary is important because this branch interprets the meaning of the laws, applies laws to individual cases, and decides if laws violate the Constitution. According to the Judiciary Organization Act of 1980, the Philippine judicial system is composed of lower courts and the highest courts.
Lower court.
A lower court or inferior court is a court from which an appeal may be taken, usually referring to courts other than Supreme Court. Municipal trial courts and municipal circuit trial court. Every municipality in the Philippines has a municipal trial court. It is called municipal court if it covers only one municipality. It is called municipal circuit court if it covers two or more municipalities.
Metropolitan trial courts and municipal trial courts in cities. Municipal trial courts inside the metropolitan area are called metropolitan trial courts. Municipal trial courts in cities outside metropolitan Manila are called municipal trial courts in cities. Regional trial courts RTC. Regional trial courts are called second-level courts and are divided into 13 judicial regions, further subdivided into several branches. RTCs are called appellate courts because these courts hear appeals and review the decisions of lower court. Sharia court. Sharia courts settle legal conflicts between Muslim Filipinos in the sphere of customary and personal laws. Court of Appeals has jurisdiction over appeals from the decision of the regional trial courts. Sandigan Bayan. This is a special court that has exclusive jurisdiction on committed violations of anti-graft and corruption laws by public officials and employees in relation to their position and office.
Highest Supreme Court. Supreme Court. The Supreme Court is the highest court in the Philippines. It is the final court that decides in any and all judicial issues. It can review, revise, reverse, modify, or affirm final judgments and orders of the lower court. The most common reason by which a cause reaches the Supreme Court is through an appeal from a decision rendered by a lower court. Appealed cases generally originate from cases tried in the trial courts. The Supreme Court does not entertain cases originally filed before it that should have been filed first with the trial courts. Functions of the Supreme Court. There are two categories in the function of the Supreme Court: administrative and judicial. Administrative functions: supervision and control over the judicial branch of the government and its employees. Declare rules for the admission into the practice of law, for legal assistance to the underprivileged, and the procedural issues to be observed in all courts throughout the country. Judicial functions: settlement of actual controversies involving rights which are legally demandable and enforceable. Judicial review of the power of the Supreme Court to inquire into the constitutionality of acts of both the consecutive and legislative branches of the government.
Composition of Supreme Court, as indicated in Article 8 of the 1987 Philippines Constitution. The Supreme Court is composed of 1 Chief Justice and 14 Associate Justice. The Philippines President appoints member of judiciary from the list submitted by the Judicial and Bar Council, which is under supervision of the Supreme Court. Tenure of service. The term of office Supreme Court members is not fixed. Their tenure during good behavior is until they reach 70 years old or become incapacitated to perform their duties. They can be removed from their position only through impeachment. Sa Pilipinas, hindi fix ang tenure na service ng mga miyembro ng Korte Suprema. Hawak nila ang kanilang posisyon panahon ng mabuting pag-uugali hanggang sa umabot sila sa edad na 70 o mawalan ng kakayang gampanan ng kanilang mga tungkulin. Nangangahulugan ito na hanggat kaya nilang gampanan ang kanilang mga tungkulin at responsibilidad bilang maestrado o maaari silang manatili sa panunungkulan sa loob ng walang tiyak na panahon. Qualifications. Following are the requirements to be appointed to the Supreme Court. Natural-born citizens of the Philippines, at least 50 years old at the time of appointment. Must have been a judge or lower court or engaged in the practice of law in the country for 15 years or more. Must be in a person of proven competence, integrity, probity, and independence.
Katarungan Pambarangay. As of July 15, 2020, the official gazette of the Philippine government mentioned under the topic of Philippine judiciary the existence of Katarungan Pambarangay. Through Katarungan Pambarangay law, Presidential Decree number 1508, a system of amicably settling disputes at the barangay level was established. It aims to promote the speedy administration justice by casing the congestion of court dockets. The court does not take cognizance of cases filed if they are not filed first with the Katarungan Pambarangay. Rules and procedures. The Rules of Court of the Philippines as amended and the rules and regulation issued by the Supreme Court define the rules and procedures of the judiciary. These rules and regulation are in the form of administrative matters, administrative orders, circulars, memorandum circulars, memorandum orders, and OCA circulars. The Supreme Court disseminates these rules and regulations to all courts, publishes important ones in newspaper of general circulation, prints them in book or pamphlet form, and uploads them to the Supreme Court website and the Supreme Court e-library website. Appointments to the judiciary. By virtue of Article 8, Section 8, appointments to the judiciary are made by the President of the Philippines based on a list submitted by the Judicial and Bar Council, which is under the supervision of Supreme Court. Its principal function is to screen prospective appointees to any judicial post. It is composed of the Chief Justice as ex officio chairman, the Secretary of Justice and ex-representative of Congress as ex officio members, and representative of the Integrated Bar, a professor of law, a retired member of the Supreme Court, and a representative of the private sector as members.
Philippine Judicial Academy. The Philippine Judicial Academy is a training school for justices, judge, court personnel, lawyer, and aspirants to judicial posts. It was originally created by the Supreme Court on March 16, 1996 by virtue of Administrative Order Number 35-96 and was institutionalized on February 26, 1998 by virtue of Republic Act Number 8557. No appointee to the bench may commence to discharge his adjudicative function without completing the prescribed court training in the academy. Its organizational structure and administrative setup are provided for by the Supreme Court in its bank resolution. Revised AM number 114 SC PHILGA. Philippine Mediation Center. The Philippine Mediation Center was organized pursuant to the en banc Supreme Court's resolution AM number 1105 SC PHILJA dated October 16, 2001.
and in line with the objectives of the Action Program from Judicial Reforms APJR to the Congress Court dockets. Among others, the court prescribed guidelines in institutionalizing and implementing the mediation program in the Philippines. The same resolution designated the Philippine Judicial Academy as the component unit of the Supreme Court for court annex mediation and other alternative dispute resolution ADR mechanism and established the Philippine Mediation Center PMC. Mandatory Continuing Legal Education Office was organized to implement the rules on mandatory continuing legal education for members of the Integrated Bar of the Philippines, BM number 850, Mandatory Continuing Legal Education MCLE. It holds office in the Integrated Bar of the Philippines main office. Alternative Dispute Resolution or ADR System. Republic Act No. 9285 institutionalized the use of an alternative dispute resolution system, which serves to promote the speedy and impartial administration of justice and unclog the court dockets. This act should be without prejudice to the adoption of the Supreme Court of any ADR system such as mediation, conciliation, arbitration, or any combination thereof.
History of the Supreme Court. Royal Audiencia. The Royal Audiencia was established on May 5, 1583, composed of a president, 4 orders, justice, and a fiscal. The Audiencia exercised both administrative and judicial function. Its function and structure were modified in 1815 when a Chief Justice replaced its president and the number of justices was increased. It come to be known as the Audiencia. Territorial de Manila with 2 branches civil of criminal. A royal decree issued on July 24, 1861 converted it to a purely judicial body with its decision appealable to the Court of Spain. In Madrid, a territorial audiencia in Cebu and audiencia for criminal case in Vigan were organized on February 26, 1898. Philippine Revolutionary and First Republic. In the 3 phases of the Revolution, 1896 to 1897, 1898 to 1899, and 1901, the exigence of war prevented the true organization of the demonstration of justice. Katipunan Council, then the Provisional Government of Tejeros Biak na Bato, and the Revolutionary Republic proclaimed in Kawit essentially had General Emilio Aguinaldo exercising decree-making power, instituting ad hoc court and reviewing any appeals concerning their decision. In 1899, when the Malolos Constitution was ratified, it provided for a Supreme Court of Justice. President Aguinaldo proposed the appointment of Apolinario Mabini as Chief Justice, but appointment and the convening of the Supreme Court of Justice never materialized because of the Philippines-American War. American military rule. During the Philippines-American War, General Wesley Merritt suspended the audiencias when a military government was established after Manila fell to American force in August 1898. Major General Elwil S. Otis established the audiencia on May 29, 1899 by virtue of General Order No. 20, which provided for 6 Filipino members of the audiencia.
Commonwealth, Philippinization of the Supreme Court. Did you know the Supreme Court was Philippinized upon the integration of the Commonwealth of the Philippines on November 15, 1935? The composition of the court was reduced by the virtue of Commonwealth Act No. 3. It provided for a Supreme Court headed by the Chief Justice with 6 associate justices. The next one is the World War II and the Third Republic. Did you know, during World War II, the National Assembly passed legislation granting emergency powers to President Manuel L. Quezon. Chief Justice Jose Abad Santos was made concurrent Secretary of Justice and acting President of the Philippines in occupied areas. And after his capture and execution at the hand of the Japanese, the Commonwealth government in exile had no system of court. Meanwhile, the Japanese organized the Philippine Executive Commission in occupied areas on January 8, 1948, which gave way to the Second Republic in October 14, 1943. By the end of the World War II, the regular function of the court has been restored, beginning with the appointment of the new Supreme Court on June 6, 1945. On September 17, 1945, the law of the Second Republic were declared null and void. A Supreme Court decision on Ko Kim Chan v. SUB Valdez Danke and Arsenio P. Dizon recognized this. And the last of the history of Supreme Court is martial law. Did you know the Supreme Court was retained during the martial law years under rules similar to the 1935 Constitution, but with the exception few key factors. Number 1. The 1973 Constitution further increased the membership of the Supreme Court to 15 with 2 divisions. Number 2. The process by which Chief Justice and Associate Justices are appointed was changed under the grant of the President. The President that time during martial law is ex-President Ferdinand Marcos. The sole authority to appoint members of the Supreme Court, there were 5 Chief Justices that were appointed under this provision. Now, we proceed to the present-day Supreme Court. Pursuant to the provision of the 1988 Constitution, the Supreme Court is composed of a Chief Justice and 14 Associate Justices who serve until the age of 70. The Judiciary Reorganization Act of 1980 transferred the administrative supervision of all courts and their personnel from Department of Justice to the Supreme Court. This was affirmed by Article 8, Section 6 of the 1987 Constitution. To effectively discharge the Constitution mandate, the Office of the Court Administrator, or OCA, was created under Presidential Decree No. 828 as amended by Presidential Decree No. 842 and its function further strengthened by the resolution of the Supreme Court dated October 24, 1996. According to the 1987 Constitution, Article 8, Section 5, the Supreme Court exercises the following powers. Number 1. Exercise jurisdiction over cases affecting ambassadors, other public ministers and consuls, and over petition of certiorari prohibition, mandamus, quo warranto, and habeas corpus. Number 2. Review, revise, reverse, modify, or affirm on appeal of certiorari as the law of the rules of court may provide final judgments and order of lower courts in all cases in which the constitutionality or validity of any treaty, internationally or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. Next, all cases involving the legality of any tax, impose, assessment, or toll, or any penalty imposed in relation thereto, all cases in which the jurisdiction of any lower courts is in issue, all criminal cases in which the penalty imposed the reclusion perpetua or higher, and last, all cases in which only an error or question of law is involved. Number 3. Assign temporarily judges of the lower courts to other situations as public interest may require. Such temporary assignments shall not exceed 6 months without the consent of the judge concerned. And lastly, number 4. Order a change of venue or place of trial to avoid a miscarriage of justice.
Rio Lourdes Serrano, born on July 2, 1960, is a Filipino lawyer and judge who served as de facto Chief Justice of the Supreme Court of the Philippines. She became the second
Full
youngest
roster of
person
Chief
at the age of
Justices.
52
The
to assume
position
the
of
post of
Chief
Chief
Justice was
Justice in
created
August
in 1901 by
2012.
virtue
She
of
is
the
considered to
establishment
be
of
the
the
first woman
Philippine
head of the
Supreme Court.
judicial branch
At
in
the
any
time,
Southeast
the
Asian
Chief Justice was appointed
sovereign
by the
state.
President of United States.
She was removed
The
from
court was
office by
composed
way of
mainly
an
of American
8-6
citizens
decision
with
by
a
the
Filipino
Supreme Court
Chief
over a
Justice.
quoranto petition, rendering her appointment as Chief Justice null and void. Sereno had faced criticism from the administration of President Rodrigo Duterte for expressing her criticism of his Philippine drug war, and some saw the petition as politically motivated. At the same time she was removed from office, Sereno had also been facing an impeachment trial prior to the granting of the petition, but after its granting, such trial became moot and was never scheduled.
Chief Justices listed according to the appointing President of the Philippines. Of the 15 presidents of the Philippines, only 8 have been able to appoint an individual to the highest judicial post in the land. The following is the list of presidents who appointed chief justices and their appointees. Number 1. Manuel L. Quezon, Jose Abad Santos. 2. Sergio Josmeña, Manuel B. Moran. 3. Elpidio Corino, Ricardo M. Paras. 4. Carlos P. Garcia, Cesar Bengzon. 5. Ferdinand E. Marcos, Roberto B. Concepcion, Kirobe Macalintal, Fred Ruiz Castro, Enrique M. Fernando, Felix V. Macasiar, Ramon C. Aquino. Number 6. Corazon C. Aquino, Claudio Tijanque, Pedro L. Yap, Marcelo B. Fernan, Andres R. Narvasa. Number 7. Joseph Ejercito Estrada, Hilario G. David. Number 8. Gloria Macapagal Arroyo, Artemio Panganiban, Renato Puno, Renato C. Corona. Number 9. Benigno S. Aquino III, Maria Lourdes P.A. Sereno.
Cayetano Arellano as the first Chief Justice of the Supreme Court of the Philippines. Cayetano Arellano played a pivotal role in establishing the judicial system of the newly independent country. He was known for his commitment to due process and the protection of individual rights. Arellano's dedication to judicial independence laid the foundation for a strong and impartial judiciary in the Philippines. Ramon Abansenia, tenure as Chief Justice coincided with a challenging period in the Philippines' history, the Japanese occupation during World War II. Despite the difficult circumstances, Abansenia demonstrated courage and resilience, refusing to compromise the independence and integrity of the judiciary. His steadfast commitment to upholding the rule of law made him a respected figure. Jose Abad Santos, Chief Justice. Jose Abad Santos is widely revered for his unwavering dedication, justice, and refusal to collaborate with the Japanese invaders. He faced crucial decisions when he was offered freedom in exchange for swearing allegiance to the Japanese puppet government. Abad Santos chose martyrdom instead, becoming a symbol of integrity and sacrifice. His commitment to justice in the face of great adversity continues to inspire generations. Manuel B. Moran, Chief Justice, made significant contributions to legal scholarship and jurisprudence. His tenure emphasized the concept of judicial activism, where courts actively interpret and apply the law to address social issues and protect individual rights. Moran believed that the judiciary had a crucial role in shaping society and advancing social justice. Roberto B. Concepcion, Chief Justice Roberto B. Concepcion was a key figure in the Philippine legal landscape. He played a crucial role in the drafting of the 1973 Constitution, which sought to establish a new political and legal framework for the country. Concepcion's leadership and vision were instrumental in recognizing, reorganizing the judiciary and implementing reforms to enhance its efficiency and effectiveness. Claudio Tihanki, Chief Justice, was known for his strong commitment to the rule of law and judicial independence. He was a highly respected jurist who made significant contribution to the development of Philippines jurisprudence. Tihanki's intellectual rigor and impartiality were evident in his judgment, earning him a reputation as a principled and fair Chief Justice. Hilario J. David presided over the Supreme Court during a critical period in the Philippine history. He played a key role in upholding the rule of law and restoring public trust in the judiciary. Notably, David presided over the impeachment trial of President Joseph Estrada, demonstrating the court's independence and commitment to justice. Maria Lourdes P. Serrano, Chief Justice, made history as the first female Chief Justice of the Supreme Court of the Philippines. She brought a fresh perspective and a focus on transparency, accountability, and access to justice. Serrano actively pursued judicial reforms, including the enhancement of ecosystems and the improvement of court efficiency. She also championed the rights of marginalized groups, aiming to make the justice system more inclusive and responsive to the needs of all citizens. Overall, these notable Chief Justices have left indelibly marks of the Philippines judiciary. Their contributions have shaped the legal landscape, upheld the principles of justice and the rule of law, and ensured the judiciary's independence and integrity.
Court of Appeals.
Court of Appeals is the second highest tribunal in the country, which was established on February 1, 1936 by virtue of Commonwealth Act No. 3. The current form of the Court of Appeals was constituted through Batas Pambansa Building 129 as amended by Executive Order No. 33S 1986, Republic Act No. 7902, and Republic Act No. 8246. The jurisdiction of the Court of Appeals are as follows. Original jurisdiction to issue rights of mandamus, probation, certiorari, habeas corpus, and qua warranto and auxiliary rights are processed whether or not in aid of its appellate jurisdiction. Number 2. Exclusive original jurisdiction over action for annulment of judgment of original trial courts. And number 3. Exclusive appellate jurisdiction over all final judgment, resolution, orders or award of original trial courts and quasi-judicial agencies, instrumentalities, boards, or commission. The Court of Appeals shall also have the power to try cases and conduct hearings, receive evidence, and perform acts necessary to resolve punctual issues raised in cases falling within its original appellate jurisdiction, including the power to grant and conduct new trials or proceedings. The The Court of Appeals is composed of one presiding justice and 68 associate justice, all of which are appointed by the President from a shortlist submitted by the Judicial and Bar Council. The associate justice shall have precedence according to the dates or order in case of similar appointment dates of their respective appointments. Disqualification for the justice of the Supreme Court also apply to members of the Court of Appeals. The current presiding justice of the Court of Appeals is Andres Reyes Jr., who is set to retire on May 11, 2020.
Court of Tax Appeals. The Court of Tax Appeals, CTA, which is of the same level as the Court of Appeals, was created by virtue of Republic Act No. 1125, which was signed into law on June 16, 1954. Its present-day form was constitute through RA 1125, as amended by Republic Act No. 9282 and Republic Act No. 9503. There are three types of CTA exercises jurisdiction in the following. Number 1. Exclusive appellate jurisdiction to review by appeal as herein provided. Decision of the Commissioner of Internal Revenue in cases involving disputed assessment, refunds of internal revenue taxes, fees or other charges, penalties in relation thereto, or other matters arising under the national, internal revenue or other laws. Number 2. Jurisdiction over cases involving criminal offenses as herein provided. Exclusive original jurisdiction over all criminal offenses arising from violation of the National Internal Revenue Code or Tariff and Customs Code and other laws administered by the Bureau of Internal Revenue or other Bureau of Customs provided. However, that offenses are felonies mentioned in the paragraph where the principal amount of taxes and fees, exclusive of charges and penalties, claimed as less than 1 million or where there is no specified amount claimed shall be tried by the regular courts and the jurisdiction of CTA shall be appellate. Number 3. Jurisdiction over tax collection cases as herein provided. Exclusive original jurisdiction in tax collection cases involving final and executory assessment for taxes, fees, charges, and penalties provided. However, the collection cases where the principal amount of taxes and fees, exclusive of charges and penalties, claimed as is less than 1 million pesos shall be tried by the proper municipal trial court, metropolitan trial court, and the regional trial court. The CTA is composed of one presiding justice and 8 associate justice, all of which are appointed by the President from a shortlist submitted by the Judicial and Bar Council. The associate justice shall have precedence according to the dates or order in case of similar appointment dates of their respective appointments. The qualification for the justices of the Court of Appeals also apply to members of CTA. The current presiding justice of the CTA is Roman Del Rosario, who is set to retire on October 6, 2025.
Sandigang Bayan, to attain the highest norms of official conduct among official and employees in the government, the creation of the special graft court to be known as the Sandigang Bayan was provided for in Article 13, Section 5 of the 1973 Constitution. This court was formally established through Presidential Decree Number 1606, which was signed into law of December 10, 1978.